everybody. How are y'all doing? Happy Friday. Happy Friday. It's Celebrate Diversity Month, number 1. I'm here to talk to you today about trademark battles, and I have a special guest. She is a trademark attorney, Jordan Franklin. You may know her on here as Jovant Garde is her name on Instagram. But we're going to be talking about different trademark incidences and issues. So everybody knows that Lil Nas X had a video that went viral recently where he was twerking on the devil. I know a lot of people saw that part. So the video went viral. He had these, I guess they call them Satans, some Satan shoes. And basically Nike ended up suing the company that made the shoes, and then they were referencing Lil Nas X. So Lil Nas was involved in it. That same company also made some Jesus shoes a little bit a while back where Nike didn't care about it. So it was a big deal among sneakerheads all over the country. I'm not a sneakerhead, however. Oh, she's right there, so let me add her. I'm not a sneakerhead, so I couldn't actually identify with the sneakerheads, but I was in this story. So then Nike ended up having, it was like a video written about Nike. Hello. It was a video. It was a letter by Nike where they were basically saying that Nike. I'm sorry, it was by USPS. It was a letter, and they were saying that Nike is using USPS logo and their intellectual property, so to speak, and they shouldn't be doing that. So that's kind of why I hit up my favorite trademark attorney in the world. I'm gonna have to get down because the same issue with you. I'm gonna have to get.
I felt like Wizard Kelly. Y'all see this down.
Yeah, as soon as I joined it, it made my video go up. So how are you doing today, Miss Ma'am?
I am running today, honey. So I'm like finishing up my lunch.
Girl, listen, the hard work does not stop. It does not stop. I understand.
I usually try to keep my Fridays light, but it was like this Friday was like, oh no, ma'am, and no light today. Like you got work to do. I've been like all over.
So are you were you in court today, or were you working on some stuff at home?
Just working on a lot of stuff. Trying to wrap up stuff. My homegirl Abby said it's the Baylor for me. You know.
Yes.
I'm still on a high. Still on a high. But yeah, no, it's just like Friday's my catch up day. Because I have so many calls and stuff during the week. So I limit like meetings and calls and stuff on Fridays because that's normally the day where I'm trying to like wrap up emails and, you know, send out stuff and respond to, you know, office actions for trademarks that I filed. Just like literally like down the list. It's like my catch up day.
Wow.
So
yeah.
I ended up having to be in meetings today. So that just kind of makes the day significantly longer.
Right.
And then I got a wedding later. So I'm just like, that's why I'm back at home. Because I'm like, I'm going to have to do something with this head. And my makeup on.
You've been at weddings a lot lately.
Girl, listen. This time, at least I'm just a guest. Thank God. Because
okay.
I'm in a few. And they are wearing me thin.
Right. So I have a question about trademarks for the people who are watching. Can you give just a layman's terms definition of the difference? Because people get confused with trademarks and copyrights and everything like that. Can you just give us a little bit on that?
Yeah, absolutely. So I think people hear the term like intellectual property thrown around. They don't really know like what it means, like what it includes, whatever. So intellectual property is primarily an umbrella term that we use to describe areas of law that attach to the tangible creations of your imagination, let's just say.
Okay.
So the three main areas underneath intellectual property law are trademarks, patents, and copyrights. So each one of them protects something different. Because I've heard people say, "Oh, I need to patent my name, or I need to copyright this invention." You know, so they're kind of getting they're not even kind of, they are getting the names confused.
Right.
So patent protects inventions. Let's just summarize it. These are just SparkNotes version. I'm not giving y'all like the U.S. code, like the
right.
So patents protect inventions primarily of some sort, either utility or of a design nature, or even like a plant patent. So patents protect inventions. That's one. Two, trademarks. They protect what I like to call your brand identifiers. So that's your name, that's your logo, that's a slogan. In very, very rare circumstances, you can protect or trademark colors, smells, and sounds. Super rare, but that can happen. And then the third is a copyright. And the copyright, I like to sum up, protects your artistic expressions. So copyrights protect things like music. They protect films. They protect films or any other kind of video. They protect, like, let's say, a book, like the manuscript of a book, visual art, whether that's sculptural, painting, digital, jewelry design, like all falls under copyright protection. So each one is considered intellectual property, but they house something different. Yes, you can trademark smells. Two examples of trademark smells. As soon as you say the name of what it is, you automatically associate with the smell. So two examples. One is Play-Doh. Play-Doh is a copyrighted smell. You say Play-Doh, you automatically know what Play-Doh smells like. The second is baby lotion. So right. It's like you can say, ooh, that smells like baby lotion, and you automatically like have a smell that you associate with that. So I think Jay-Z once trademarked Jay-Z Blue as a color or as like a phrase. I guess we'll get into questions later. Yeah, but
right, y'all can actually have, again, this is Attorney Jordan Franklin. Make sure you follow her. You can click up there and follow her. She's a trademark attorney. She's done a lot of different trademarks, either with small businesses and also in the entertainment industry. Also, if you want to ask a question, you could just click that little box and then ask a question and we'll answer it at the end. So I was letting everybody know that we're talking about kind of like quote unquote hot topics. I know that it was a lot of stuff going on Twitter. What happened on Twitter? What happened where you said, so when after Lil Nas X went viral, you said that what's the company called? MSHF, whatever.
Yeah.
Whatever that company is.
CHF, I think like that.
Yes. Yeah. You said that they were suing Nike, or Nike was suing Lil Nas X via that company. So obviously the people on Twitter don't understand, oh, it's not Lil Nas X. Obviously he's involved in it. But what happened? Like people just assumed, from what I saw, it looked like people assumed that Nike was doing something that was out of pocket. There was no way in hell that Nike even had a claim.
Yeah. That's a huge common misconception. Yeah. Somebody put the name MSCHF. Yeah, that's them.
Yeah.
Yeah. A lot of people are like, oh, this is DOA, dead on arrival. For those that don't know what DOA means, they were like, oh, it was DOA. Oh, it's going to get tossed. Oh, Nike doesn't have any claims, blah, blah, blah. No. Nike definitely had claims. Like now the case has settled, or is in the process of quote unquote settling, between the two of them. So like, we'll see what happens with that. But, you be frying them up on Twitter. I be trying to be like real nice about it. But I'm like, people like legit act like I don't know what I'm talking about. But Nike definitely had a very strong claim, because there was a severe likelihood of confusion, which is like the whole premise of trademarks, to prevent consumer confusion in the marketplace. That's what the law says, to kind of sum it up. So,
yeah, and my thing is...
Well, to answer that question, we do know what his relationship was with MSCHF. They had a collaboration together, actually. Now, whether or not that collaboration was under contract, I don't know. But even in the body of Nike's original complaint, they talked about and they mentioned the collaboration between Lil Nas X and MSCHF. So we do know what the relationship was between the two of them. It was some type of collaboration. Again, whether or not that was deduced to like a collaboration agreement as far as a contract, we don't know. We don't know if that contract existed, but there was a relationship.
Right. And so my thing is, when I looked at the complaint, because people were telling me that there wasn't even a complaint. Like, people were saying it's fake news. I'm like, where's everybody getting this from? So I was on vacation, first of all, and I come back and all hell is breaking loose on the timeline. I see people coming at you. I'm like, hold on. So when I next selling shoes, like, and at first I thought it was fake. I was like, is he selling fake Nikes? And all the sneakerheads is in my mentions. Like, it's not fake Nikes. It's real Nikes. All of this stuff. And I was like, okay. And they were like, well, there's no claim. There's no real claim. I was like, actually, there is, because I just saw a complaint. Nike actually filed a complaint.
Yeah.
And they were talking about trademark infringement and trademark dilution. Yep. What are the main differences between those? I mean, I know that they said some other stuff too.
They normally run neck and neck. So when you look at trademark confusion, trademark infringement, that goes back to what I was saying about consumer confusion in the marketplace. The biggest example of that was how people thought they thought that they were involved. They thought it was a legit Nike shoe that Nike customized and is selling.
Yes.
So that's the consumer confusion in the marketplace. So then there's a few things that are and then too, like, their dumbasses, excuse my language, left the checks on the shoe. And so it's an unauthorized use of somebody else's because they even admitted that they bought a bunch of Air Max 97s, just black ones, and then they altered them.
Right.
So, I mean, that's Nike's branding. Like, that, those swooshes are trademarked. So you continuing to use a swoosh on a product that is not technically theirs anymore, like that, without having to go down the elements, that's essentially the infringement portion. The dilution portion. So dilution comes in, and it primarily happens with larger brands. But dilution with a brand comes in where they feel like you doing something. You said I'm good on language. I try to make sure, I keep it real ladylike, because I do cuss like a sailor.
Me too.
But
me too.
Okay, I try to keep it real censored. It's a family show. So dilution comes in basically where I'd like to summarize dilution as tarnishment. I think that may be the easiest way to understand. And with this situation, not my sister co-signing. That's my little sister talking about But so tarnishment, I think, is the easiest way to understand dilution. So Nike received a lot of backlash when this shoe came out. They were even posting tweets and petitions that people were signing about not wanting to support Nike anymore because of the shoe. And it's like, Nike, to me, this is not funny, but it's hilarious. Nike was like that Nene Leakes video. Like, now why am I in it? See,
right.
I didn't even do nothing. Like, that was literally Nike.
They had no idea. What the
zero idea. They had no involvement. And so, like, because of all the backlash, that's kind of where the tarnishment piece comes in, which then in turn kind of turns into dilution. So I usually like to say, without like getting too legally technical, the best way to think of trademark dilution is tarnishment of your brand.
Right.
So somebody else's actions and using your brand without your permission is causing some type of negative reflection on your brand. That's basically what dilution is in like simplified terms. So that's why when you see big brands sue for trademark infringement, dilution is going to almost always accompany it.
And see, my thing was, people were trying to compare it to what happened with the Jesus shoes, right? So dilution it definitely comes into play there, because when that same company, I guess they altered some other shoes that didn't tarnish their brand. Right. Now, having something with Jesus on it did not tarnish them. It wasn't people that were protesting against them or saying that they wouldn't deal with them. But when you have something with Satan on it, because Satan, it has a lot of negative connotations, especially in places that are like the Bible Belt and things like that. I mean, our country, we say one nation under God, like it's all indoctrinated. So when you put something like Satan on there, it to me, it was like, I was like, Nike's going to win on a lot of points, honestly, if they did go forward.
I mean, I have to touch on a question. A girl, she said, princess.sss says, so if it's not negative, then it's fine. No. That's not the threshold, whether or not it's negative. The more negative it is, the more likely there is going to be a dilution claim. But with this situation too, because people did bring up the Jesus shoes, there were a lot of differences between the two.
Yes.
And see, he's taking the words right out of my mouth. Significantly smaller launch. Like the Jesus shoes sold, I want to say less than 50 pair. This one sold over 650 pair. There's a significantly larger commercial impact.
And it seems like it was promoted more too. Like, I don't know if they had a big marketing push, but
they did. And that's where Lil Nas X comes in, because of the size of his platform. There was a lot more publicity, a lot more marketing, and all that stuff done for this shoe. I don't believe that there was any celebrity at all, but there was no celebrity attached to the Jesus shoe. They just did it and launched it. You know what I mean? Mm. So the commercial impact was significantly less with the Jesus shoe, because like I said, they sold less. And then of course, like the actual like push and the marketing and all that stuff was a lot less with the Jesus shoe too.
Okay, so what about, so another question that I got, and then we do have some more questions too. So another question that people were asking me on Twitter, they were saying, well, does Nike, so Nike is the owner of that trademark. What type of protections do they have? Like, they were confused. Like, how can Nike say that this is okay and then say that that is not okay? Can you just talk about that? Because they were like, what type of power do you have once you get that trademark?
All the power in the world. And you also,
right,
as a brand, the thing that I think people mistake, and see, I work with a lot of creatives. And I will say some creatives do have a sense of entitlement. Just because you are a small creative doesn't mean you can do whatever you want to do. So that's one. Two is Nike can determine where they draw that line in the sand. Exactly. As you know, and as everybody I'm sure knows, is you've never heard of Nike coming after people who do a limited edition shoe and it's one or two pair, right? Or, you know, Nike actually encourages customization, hence the Nike ID you can even do on their website. So that's not an issue. Sneaker culture is not an issue. Doing, you know, limited releases is not an issue. But at some point as a brand, you have a duty to draw the line in the sand on what is either infringing on, you know, your brand, or somehow compromising or could potentially compromise the integrity of your brand. You have a duty to do that. And so that's what Nike did, essentially. They're like, okay, look, we let y'all get away with a lot, including, like, you know, selling a customized shoe for $50,000. We let y'all get away with that shit. But at some point we have to draw a line. Because again, like, people see where Nike is now, but somebody had to work to that point. Like, it didn't happen overnight. And so
for that
they
recognition of that trademark. Like, you're like, I don't think that Nike's, because this is my thing. If Nike shouldn't have the power to take it away or whatever, do people think that Lil Nas X could have came out with his own Lil Nas shoe that wasn't Air Max, that wasn't Nike, and it still would have had that same demand? I don't think so. They attached it to Nike for a reason. It's valuable. So I think
and my thing is too, to add to that, no one can sit up here and say Air Max 97 is not a recognizable shoe.
Oh yeah, everybody knows that that's the Air Maxes. Yeah. So
yeah, Nike is in control. But see, here's the thing: it's not even just Nike. A brand is in control, because let's look at it this way: there's so much uproar on social media when bigger companies like Fashion Nova are profiting off of the backs of smaller designers. Just because one is of another size compared to another doesn't mean that it's okay for someone to still profit off of the back of what they've built as a brand. You see what I'm saying? So it's like, if we, you know, root for small designers against the Fashion Novas, Nike also has worked very hard to get where they are and, you know, have longevity as a brand. And you shouldn't want anybody to be able to profit off of their backs either, especially when, again, like, Nike got a lot of backlash for something that they weren't even involved in. They were just like, damn, we didn't even do that. Like, how y'all petitioning to, like, never support us again, which is messing with our money. We didn't even do nothing.
Right. And this is where the confusion comes in with attorneys and Twitter lawyers. Because the Twitter lawyers were saying Nike doesn't have the right to do this. Actually, they do. Nike doesn't have claims. Actually, they do. Nike, Then it turned to, okay, well, since they have all of that, you're supporting big companies that are preying on smaller. That's not what it is. Like, come on. It turned into that.
It's literally, like, and somebody said that I was homophobic because I was excited about the lawsuit. And I'm just like, first of all, I'm actually a huge ally. Like, everybody in the community here knows that I am an ally. If you don't know me, sure, whatever. But I'm like, I didn't even mention his orientation because that's irrelevant in a trademark situation. It is black and white. Is there infringement? Like, are you, profiting off of the back of somebody else? Are you, not even just that, are you using somebody's brand without their permission? And the answer to that was yes. Like, if you want to use it, take the check off next time. Okay? How about that? Y'all left the checks on the tongue, on the side. The shoe still said Nike.
The shoe still said Nike.
If you're going to do it, like, remove it. But I'm like, people were just reaching for straws because I'm just like, why? I didn't even mention his orientation. Why? How am I homophobic? Because I know the law. Like, I do this every day. I do trademarks every day. And I think
we're talking about it from this little side. Like, we're talking about the law. Everybody
it's the law.
See, we went to law school and we learned that emotions and the law do not mix. It is,
and that's the thing. And see, people were mixing a lot of their own personal views and opinions, and because of the fact that I am Christian and I'm not ashamed to hide that. Someone said something about how I'm a brainwashed Christian and I'm homophobic. I was like, let me tell you something. I said, first of all, people need to stop putting all Christians in the same box because I got my blessed oil and my sage in the same drawer. So it's just like, You heard me cussing earlier. You know what I'm saying? I listen to Megan Thee Stallion and Young Dolph every other day, but then I'll flip it and put Tasha Scruggs on. So it's just like, no one Christian looks the same. No one person looks the same. But I didn't even bring any of those up.
Honestly, we didn't get involved until the shoe thing came up. So I didn't even see the video. First of all, I did not see the video. I did not hear the song. Who cares?
I haven't seen the video or heard the song either.
So we're not even involved in that. So when the video and the song came out, that's when people were talking about homophobic stuff. We weren't even involved in that. The only time the lawyers' ears go up when lawsuits happen. That's when we're like, okay.
And especially a trademark lawsuit. Like, I do this every day. This is literally what I do every single day. So I'm just like, y'all can, say what you want to say, but what is the situation of Nikes? When is the line for remaking? I can't tell you where that line is because I don't work for Nike, but ordinarily, if it's just a few pair, if it's something you create for yourself, even if you sell a few, normally that's fine. Like, again, kind of going back to Nike's history, you have not seen Nike sue people for making customs, right? But I don't know any person who does customs, and I date a lot of sneakerheads. I don't know anybody who makes custom shoes that sells more than 50 pair.
Yeah, that launch was crazy.
When you start getting into mass production, that's when there's going to definitely be a problem, especially when you're mass producing a custom shoe, but you still have the branding, the registered trademark branding of another brand. That's going to be a problem.
Yeah. So another thing that happened, in the complaint, Nike was saying they wanted, in the initial complaint, it was saying that they wanted the earnings. They said they wanted to stop production. They said they wanted, they said a recall. And now that the settlement is on the table, and we don't know what exactly is in the settlement, but people on both sides were saying that they're definitely going to do a recall if people want to return the shoes because they mistakenly thought, or they got the brands confused. They can return the shoes, and people were telling me it's not going to be there. I'm like, I'm just telling you I was in the complaint. They requested that. And honestly, Nike was getting little wins here and there. And that's why I think that company decided that they wanted to go ahead and settle. I mean, it doesn't make sense for them to fight Nike.
I wanted to be a knockout, drag out fight. I'm talking about I wanted UFC in the octagon. But most cases, I don't think people realize that only 1% of 1% of cases actually make it to trial.
Yeah,
so it's not
criminal, anything.
Yeah, it is not uncommon to settle because most people are like, shit, I'd rather settle, maybe pay some lump sum as opposed to a lawsuit that could probably take years. Something of this magnitude would take years, which means you paying years of attorney's fees.
Right.
And them attorneys that they were hiring, or those law, did you see those law firms that were?
Oh, the big law? Oh, yeah. I was like,
you're paying. There's multiple attorneys. It was like at least 3 or 4 on their team. Each one probably has a minimum of like $300 per hour billing rate. So it's like, who want to pay all of that for 2 years? So yeah, let's figure out what we can do to talk settlement.
And I think that Nike is probably willing to negotiate. You know, I can see Nike. Now, this is the thing. They said that they would do a recall and people can get their full refund. I slick don't think that Nike want their little money, but they definitely want them to shut it down.
Yeah, I don't think it was a money thing. Clearly, Nike's not worried because I know my ass for sure drops a bunch of money in Nike weekly. But because like all my golf clothes are Nike, most of my workout clothes are Nike. But I think it was more so them allowing people to see where that line in the sand is drawn. Yeah, so it's like, if you want to do it, then, you know, by all means, create, sell, customize, but understand that if you get up to here, you've gone too far and there could be consequences.
Right. I think it was a message for sure. I'm so glad that we made the distinction between everything. So Jordan has to go, but I got a meeting at 3. Yeah, she has a meeting right now. So I'm at one question. So somebody said, how is what Lil Nas X did different from, let's say, someone using a Hanes shirt and putting a logo on it and selling it?
Depending on what that logo is that they put on that Hanes shirt, they could still have the same problem. Because the problem is not what you're using. The problem is what you're using and whether or not what you're using is a registered trademark of somebody else.
You just ended it right there.
So, what is it? I'm not sure if you saw the Air K. What's Air KY?
No, I didn't see that.
I don't know what
I saw the question, but I don't know what Air KY is.
I don't either.
Last question.
Are we old?
Right, we are. I'm like, and then I'm not a sneakerhead. That's what I'm saying. I'm like, listen, the sneakerheads are mad at me for just asking the questions. I'm like, I'm just asking. Yeah, we could do a part 2 of this, y'all. Let me know if y'all like it. Make sure y'all follow her and comment. Add me if y'all don't follow me at Natasha M. Scruggs, and definitely follow her. And I'm going to let her go because she's a very hardworking attorney. Thank you so much for spending your time with us, squeezing us in, and I hope you have a great Friday.
Oh, well, let me answer this one real quick.
Okay.
She said it looks like a Nike Jordan 1. That is going into what's called trade dress protection. Now, Nike actually did recently, instead of the check, it's the lightning bolt. Okay, so here's the thing. So,
I saw that.
Yeah, so you can actually protect the silhouette of a shoe. That can be done either with a design patent, or more people do now what's called a trade dress, which is kind of like the birth child of a trademark and a design patent. Nike actually did file an application recently to protect the silhouette of a Jordan 1 because they actually already have a patent for the 4s, the 3s, and then another style of Jordan. But if they get this trade dress registration, brands like that, they can't actually shut down, but they would have to obtain it first. Now, they could go about it in another way. They can like potentially sue, I guess, for likelihood of confusion for like, it's like, so trademarks are primarily federal, but you can also sue almost on the state level, which they call common law trademarks. So because they don't have a registration in it, but they have what's called acquired distinctiveness or brand recognition for that shape of the shoe, for that style, that they could, I guess they could make a claim and go after that. It'll be a lot harder to prove, which is why they went ahead and filed for the trade dress. I know that was like super legally technical, but
but that's the answer. I mean,
yeah,
I did see that lightning bolt too. I did see that, and I was kind of wondering that. So that's a great question. Thank you, Simply Unjaded. Thank you.
I wish I could answer more, but yeah, I don't want to have my client waiting. I literally got the Zoom pulled up.
Right. So yes, we will do another part 2. Let me know. Comment on my page if y'all want us to do a part 2.
Yes, let me know. We definitely do part 2.
Yes. Have a great day.
We didn't even talk about the postal service shoe.
I know. I wanted to get into that. So next time we can talk about that.
Absolutely. But thank you so much for having me.
Bye.
Bye. Have a good weekend.
You too.